Chapter 3, the court system. Let's take a look at how our courts are set up here in the U.S. and maybe even specifically here in Montana. We'll take a look here. That's just some articles that I've done in the past.
J'étais embarqué dans un camion de livraison, et puis j'atterris ici. Oh, c'est incroyable. Hein? T'entends ça, chérie?
Ah oui, c'est fou.
Okay, so what did that have to do with the court system? Absolutely nothing. Sorry if the video quality or audio wasn't that good, but I hope you got a sense of it. I always found that one to be kind of humorous. So why do we study law, right? Corporate governance in a property-based environment. We have to have a viable court system. Believe me, in my time in banking, I engaged with agents of the court and the court itself practically every day. Let's say on average every day. There were probably some days where I did almost nothing but, I'm sure there were some days when I did nothing but engage with the court system, and other days when I may not have had that much interaction, but not many days went by when we didn't have some sort of interaction with the legal system, I should say. And we needed the courts to enforce, our contracts. Okay, we had to, we lent money and people were supposed to pay us back, and sometimes they didn't, and we had to enforce that. And we made agreements with other people, other banks, other institutions, and there again, those we had to rely on those being enforced. And we spent a lot of time too, unfortunately, not a lot, but decent amount, working with the bankruptcy courts, which, by the way, bankruptcy courts are a federal court system, okay, dealing with some of our customers who were unfortunately had to use that in order to try to reorganize their lives, okay, or their businesses. So you got to have an understanding, and I teach this class, but I'm not an attorney, and yet I can tell you that, like I said earlier, I spent a lot of time in my banking career dealing with the legal system, an awful lot of time dealing with the legal system. Too much time. I'm sure that just about anybody in that industry would tell you way too much time, and so you have to develop an understanding of it. Like you, I had a business law class. Like you, it didn't teach me anywhere near all the things that I needed to know, when I was in the business world, and so learn what you can, and then understand that this is just a real bare bones that as you get in the business world, and no matter what you do as an employee or whatever, you will have a need to understand the legal system and the court system in Montana and the federal court system possibly as well. So it can be involved in court cases, certainly as a party. The bank often was, like we said, oftentimes when I started in banking, banks were getting sued. Back then it was for bad faith. I kind of date myself, but I could tell you some good stories about being sued for bad faith and what was happening then. And so the bank was a party, was a defendant. Then in many cases, bank also was the plaintiff in many cases, because we had to sue people to get our money back. As individuals then, we were often called as witnesses, depending on the case again. as a witness for the bank, as a witness for whoever. So, yeah, it definitely took all those parts in my career, and even after I left the bank, I was called back. Several things that were pending at the bank, I got called back. I don't know about several, but a few anyhow, and had to serve as a witness. Never in court, but in depositions at least. Soaring legal costs, and I kind of changed this one that I have here is different than the one I've posted because I kind of wanted to update it. We talk about soaring legal costs, and I think your guys' shows Tyco and Quest, $50 million and $75 million settlements. Heck, the settlement that Wells Fargo just made was 70 or 80 million dollars, somewhere in that neighborhood. But even that pales. That's peanuts. It's actually peanuts for Wells. Look at as a result of the financial crisis that we went through here, 2007, 8 in that area. Citigroup has paid over $7 billion in fines and settlements. J.P. Morgan, $13 billion, and Bank of America, over $16.5 billion. That's just the three biggest. There were a number of other banks, Wells included, that have paid billions of dollars. I think they said the total fines and settlements paid by the banks totaled over $110 billion. Okay, just huge, huge. And it's not limited to the banking industry. They've been in the news, and they'll be in the news as we go through the election cycle, that everybody hates the banks and how bad they screwed America. Okay, and so they'll be the candidates will both talk down about them in an effort to win some votes. Okay, but they've paid a ton of money in these fines, as have other industries. I see Montana's trying to, there's some legislators that want to propose a law coming up that would fine the coal industry basically for shutting down in Montana, even though they don't really have a choice. It seems like an odd law to me, but it'd be a good one, I guess, to post. I might have to look that up. Judges and justices, judges, magistrates, and justices, they all titles infer similar powers, I guess you would say. Okay, in the state of Montana, federal judges, we have, I think, 3 of them, if I'm not mistaken, but below them are several magistrates, and the magistrates rule on things just like the judges do, perhaps given lower, less meaningful cases than maybe the judges are. Justices, I think, is a term that we oftentimes use for those that sit just on appellate courts, but also like our Supreme Court. Of course, our Supreme Court is just an appellate court. Other than we would have a chief judge. Okay, so kind of interchangeable terms, I guess. I don't know that we need to worry about, and don't worry about, distinguishing between the two. But they determine the rules of law for the case. They set, in a jury trial, for example, that's really all they do is kind of set the rules for the trial and whatnot, right, which is determining the laws, okay, and the jury then finds the facts. But cases sometimes will have a judge decide those facts, and the party, usually the defendant, I believe, is the party that gets to choose that. Okay, they may choose to have a judge decide. In the bank, a few times when we were sued for bad faith, that would be our election. We would say, no, we'd rather just have a judge. Oftentimes, juries are sympathetic, or it's easy to portray a bank or a business, as having deep pockets, and they won't mind paying $1 million or $10 million to the plaintiff that might be suing in that case, and so you might rely more on a judge in a case like that. Okay. A trial judge can render decisions on people conflicts, so civil cases. These can be jury as well. They can be a jury trial. Okay, and the judge, judges can both set the rules and whatnot. A judge can also overturn basically a jury's decision, a judgment notwithstanding, I believe that's called, and we'll talk about that actually next chapter. So justices deal with issues of law and appeal. Okay, and the judiciary has the power of judicial review, is what we say there, which is the power to review laws and determine their constitutionality or not, is generally what they deal with there. Jurors, right? Fact-finding body. Petit jury is just another word for jury. Usually it's 12. There's provisions in some states, okay, not for federal courts, I don't think, but in some states there's provisions for smaller juries. They've kind of found that, a jury of 9 or a jury of 6 might come up typically with decisions that would be similar as a jury of 12, and obviously less expensive and easier to seat a smaller jury, easier to find the jurors in, right? In a criminal case, it's usually unanimous, okay? Usually unanimous. I think in the state of Montana there's no provision for criminal cases to be less than unanimous, okay? So everybody has to agree. If the person's to be found guilty, every juror has to say guilty, okay? If the person is to be found innocent, every juror has to say innocent, okay? No reason given. Okay, now that's criminal where the standard of proof is beyond a reasonable doubt. Again, that's something we'll talk about a little further along, but with criminal cases, it's beyond a reasonable doubt. With civil cases, one party suing another, one person suing another, it's a preponderance of evidence or a majority decision in those cases. So it's kind of how we distinguish those. Lawyers required in most cases, and the famous Miranda rights, if you can't afford a lawyer, one will be provided. They're advocates for their clients, obviously. Duty to administration of justice, counselor, advocate, public servant, all of those things. Now, they are required, I think, to do a certain amount of pro bono work. I think most states have those, right? And the communications that you have with an attorney are confidential. Our system's adversarial, right? Representative of combatants. Okay, wow, it's kind of some big words, right? Lawyers have this job, right? They present evidence, they present points of law, and they obviously present arguments. Hopefully convincing arguments for their side, right? And they function as a counselor, they function as an advocate for their clients, and as a public servant when they do work. Oftentimes the court appoints them to represent somebody, okay? The court then pays them, okay, for that representation. Generally, we follow this basic hierarchy of federal and state courts, right? There's Supreme Courts. States have Supreme Courts, as does the federal government, obviously. And there's courts of appeals, okay? And our federal government has courts of appeals. We have, we'll talk about that, but basically 12 of them. And then there are trial courts, okay? Our state really does not have a intermediate court of appeal. Our Supreme Court in our state system is the court that we rely on for appeals, okay? Now, I'll talk about this a little bit more when we get to the diagram of our state courts. I think I could explain it better if we're looking at that diagram. But this is in the federal court system, for example, Montana is one judicial district. And they kind of do that by population a little bit, right? But we have judges that serve in the federal, okay, courts. There's, like I said, 3 or 4 of them here in the state, and those can be trial courts. Okay, they can actually also serve as appellate courts, and we'll talk about that a little bit. For state actions that would come to them, they can serve as appellate courts. Okay, but at the federal level, then beyond that, there are 12 basic courts of appeals. Okay, and so federal issues after the trial can go to the Court of Appeals, and then ultimately perhaps the Supreme Court. Okay. If you looked at the federal and then state court systems kind of together, here would be the federal court system, and then below this you would put state Supreme Court, state courts of appeals, state trial courts, okay? And conceivably an issue could go all the way from a state trial court all the way up to the Supreme Court of the United States, okay? And generally speaking, they would follow that order. So what are the sources of authority, right? Constitutions, legislatures give authority, and they establish courts, rules, and procedures. Trial courts, again, have different names: Superior Court, Circuit Court, District Court. Okay, I don't think I'd get too, it's kind of like the judge, justices, and magistrates. I wouldn't get too wrapped up in worrying about what we call these trial courts. Okay, you need to understand where, like if I say state district court in Montana, you'll need to understand that that's a trial court. Okay, that's where a lawsuit or a complaint is filed. Okay, and the trial court determines facts and law, again, either with a jury that determines facts, okay, and a judge that determines law, or a judge that determines both the facts and law. Appellate courts review questions of law. Okay, they don't review the facts necessarily, but they review the questions of law. It consists of 3 to 9 judges. Our federal appellate court system, the Ninth Circuit, for example, probably has somewhere between 25 and 35 justices appointed to it. There's not a fixed number because there's almost constantly, with that many, some turnover going on, and maybe 1 or 2 justices. Like, for example, right now, the Senate's probably not going to approve anybody that Obama recommends or nominates, and wait till he's out of office, basically. So there could be some absences, right? They've retired, they've died, whatever the case may be. But then when they look at issues, okay, they would choose a panel, typically of 3 to 9 judges or justices that would review that. We had one case, that's the only one I remember, that went to the Ninth Circuit appellate court that our bank was involved in. I wasn't terribly involved in it myself. And it went to a 3-member panel from the Ninth Circuit Court. They actually met and reviewed it in Seattle, even though the headquarters is in San Francisco. Petition for leave to appeal, okay, is also known as the writ of certiorari. I've mentioned that to lawyers, and they don't necessarily know. They don't necessarily call it that. They just call it an appeal. Okay, so if we want to appeal something, that's what we do, right? We have to petition to do that. The next court can choose whether or not to listen to the appeal. If they don't, basically the issue's settled. Okay, small claims courts in Montana, our justice courts typically act as small claims courts. Our city courts can, but typically it's our justice courts, and we'll look at, again, the Montana flow chart here in a bit. So they handle litigation maybe between businesses and customers, often like landlord-tenant issues, or small bank loans, or you didn't pay your power bill, whatever the case may be. Those types of things can be handled here, right? Minor financial issues. They're informal. Oftentimes lawyers are not required, okay? Sometimes prohibited, okay? Costs are low. You don't have discovery. You don't go through a lot of those processes. The procedures are pretty simple. It's not unlike what you see on TV, believe it or not, okay? It's not unlike that. With Judge Judy or Judge Wapner or whatever the case may be. So federal courts were set up under Article 3 of the Constitution. That'd be a good test question. Which article of the Constitution established the federal courts? Right, they review questions of federal law. Okay, there are certain laws that are absolutely federal, right? The U.S. may be a party, so our administrative agencies, those types of things, right? That would go to a federal court. State disagreements, one that's I see in the news periodically. I haven't seen it lately, but it's one of the rivers that flows from Wyoming to Montana, and folks on the Montana side are complaining because some of the gas wells, I believe, on the Wyoming side, one of the byproducts is water with too much sodium in it, and they're releasing that into the river, and that's kind of ruining things for the Montana folks, et cetera, et cetera. Well, if that ever broke into a lawsuit or whatever, it would obviously have to go to a federal court to be settled. And suits between citizens, and citizens are both natural citizens, people, but can be corporations then as well. Not sure what I got there. U.S. courts, that could be our judges and whatnot. I better take a look at this for Montana, maybe. Yeah, won't find it. So federal question cases, right? Issues from the U.S. Constitution or the Bill of Rights that come up would go to federal courts, so perhaps freedom of speech issues or gun rights issues might be tried right in federal courts. Now, that said, there are, each state has its own gun laws, maybe some restrictions and whatnot, and so violations of those laws would go to state courts. So it gets to be kind of confusing, and understandably so. Okay, banks, for example, having been there, are federally protected because of the Federal Deposit Insurance Corporation, right, FDIC, that insures your deposits and whatnot. And so crimes against banks are often to go to federal court. Kidnapping, I think, with the famous pilot Charles Lindbergh, when his son was kidnapped, it caused such an outrage that they made kidnapping, at least kidnapping and then taking him across state lines, as a federal crime, if I'm not mistaken. And so those issues would go to federal courts. There's no monetary limits, right? It can be suits for damages, so it doesn't have to be criminal. It can be civil suits, right? These types of things are obviously also federal. Okay, our patent systems are federal, copyrights, trademarks, taxes, IRS taxes, not state taxes, and then some employment discrimination. States have their own employment discrimination as well. Again, this was kind of confusing, whether it would go to the state for some of these violations or whether it would go to the federal government. It depends on the industry or whom you work for that would probably make that first determination. Diversity of citizenship issues we talked about before. That's people or businesses, or people/businesses that live in separate states. The Class Action Fairness Act was passed in 2005, if I'm not mistaken. And prior to that, class action lawsuits were often filed by plaintiffs in state district courts where they knew juries were sympathetic. Okay, and it got to be a little bit carried away. As long as a company did business in that district, they could file the suit there. So if somebody sued BNSF, even if their accident had occurred in Havre, the lawsuit might take place in a district that was a little bit more suitable for the plaintiff in that case. I'm sorry, that would not be the case. But if there was an issue, because class action would require a bigger number of people. So if there was an issue against the railroad where a number of people needed representation, they would purposely seek out a state district court, wherever BN might do business, that they thought might be more sympathetic, and got to be some issues there, and so we passed this Class Action Fairness Act. And I believe if the amount's over $5 million, might be a certain number of people that have to be represented. Then those class action lawsuits have to go to federal court. The general role of an appellate court this is a while back, but they review just questions of law, right? They review questions of law. Diversity of citizenship, we kind of talked about corporations, the citizen state of its incorporation, but also state of principal business. That doesn't mean that it can only be one. Okay, so it can be considered a citizen of a state where it does a lot of business. Okay, as long as that business is not driving through the corner of the state. Okay, then you wouldn't necessarily be a citizen of that state. But for example, is Walmart a citizen of Montana? Yeah, probably. Okay. Claim must be 75,000 plus. So if my brother and he lives in Washington, if we got into a little bit of an argument and decided to sue one another over something, if it was 20 grand, we'd probably have to find a state district court to have that suit, because it's not enough to go to a federal suit. Again, we have federal district courts, and Montana is one federal district court. They can review lawsuits, so they can look at lawsuits that have come up right? Even all the way through the state, maybe it's gone through the state Supreme Court. If you to appeal from there, you could take that to a federal district court. Okay, they receive evidence, they can evaluate testimony, they can impanel juries. If they're acting as an appellate court, they don't have juries, okay, and they don't have trials. But if they're acting as a trial court, then they would have those things. So they do both, but the rules are different depending on how they're acting, whether it's as a trial court or as a appellate court. They resolve disputes, obviously, and they use the rules as set up by the federal government, which are consistent then throughout. If you ever hear me, and I kind of do sometimes, I'll pause when I say 12 U.S. Courts of Appeals, because sometimes these two down here, the U.S. Claims Court and the Court of Military Appeals, are also included, which would make it 14 then. Okay, so sometimes I pause when I do that. The U.S. Claims Court, they deal with administrative decisions, meaning that if you were having a tussle with the EPA, for example, and they had come and made an administrative action against you, and you didn't like that, you could certainly argue that, and you could take it to court, and if you did so, you would take it to the U.S. Claims Court. And the Court of Military Appeals is what it says. Obviously, if you've been through some type of court-martial or some type of a legal action within the military and wanted to appeal that, then that would go to the Court of Military Appeals. They're basically considered at the same level as these courts of appeals up here, just a little bit more specific in purpose. Which circuit court includes the state of Montana? We're in the 9th Circuit Court of Appeals. Okay. Geographically, it's the biggest, okay, by far. I think it includes Alaska, so I guess Alaska is about the size of half the continental United States, so yeah. But geographically, it's a big area. It covers I think it includes Alaska. It's headquartered in San Francisco. Includes Montana, Idaho, Washington, Oregon, California, obviously, and I think they handle some of the more of the states too. Yep, Alaska and Hawaii are both also included in there. Nevada, Arizona. So yeah, big old area, right? Alaska's a lot bigger than that. Okay, and there's been some talk at times about breaking this up into two different courts. How they would divide it, I'm not sure, but there has been some talk just because the geography and the number of cases are pretty big. You get some pretty big populations when you come down the coast. Obviously not a lot of population here, but I haven't heard that kind of talk lately. The one, they got 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. I think the one that's missing is there's a U.S. District Court that's just strictly for the District of Columbia or Washington, D.C., if I'm not mistaken. Again, writ of certiorari or an appeal, for the Supreme Court to look at it, it has to be of federal importance, right? It has to be of a constitutional issue. And it could be conflicting decisions of U.S. Circuit Courts. And so we'll see that sometimes where an issue, maybe a law, I think we saw that with Obamacare, in fact. The original decision that they made several years ago about whether or not the government had a right to require people to purchase health insurance. And, basically they say you're obligated to purchase health insurance, and if you don't, then what you're going to incur a fine. Okay, well, that was an interesting case, and it did go through a couple of different circuit courts, and they did have some different rulings before it got to the Supreme Court. Everybody awaited that decision, and the arguments were both yes and no, and ultimately, and surprisingly actually, because of the makeup of the court, they ruled that it was constitutional, and they said that the reason it was constitutional was because it wasn't really a fine, it was a tax. Okay, and the Congress can impose a tax. Had it been considered a fine, okay, it would not have passed the muster, and it wouldn't have been accepted by the Supreme Court. And that was interesting because, of course, one of the selling points of that was and I believe a few of the sellers of that made very public claims that it would not raise taxes one bit. But the Supreme Court ruled that, if it walks like a duck and quacks like a duck, it's probably a duck, meaning that it was a tax. So, and when the Supreme Court makes a decision, that's it, right? They're the end. Okay, they have the power to interpret legislation, determine constitutionality. There's a famous one year when Obama was making one of his State of the Union addresses. He was upset with the Supreme Court over a decision that they had made, or one that was before them, and as he was making his speech, he kind of alluded to this and kind of said that maybe they were overstepping their power. And famously, one of the judges, I think it was Alito, he mouthed something that lip reader said was something like "not so" or "not right" or "not correct" or something like that. It was kind of famous. If you went back, you could probably find a clip of that. Judicial restraint, judicial activism. Having a basic understanding of these would be important because it's on the test, I'm sure. But judicial restraint means that the courts kind of stay out of things a little bit, and strict constructionism, meaning strict interpretation of the Constitution or the governing documents, but primarily the Constitution then. Okay. Judicial activism, on the other cases, where courts become far more involved in situations and far more eager to correct society's, or at least what they deem to be society's, wrongs. Okay. Is the power of judicial review important? Absolutely. Absolutely. It's a kind of an untouchable group of people that have the power to render laws either constitutional or unconstitutional. Okay, had the Supreme Court ruled the other way with Obamacare, it would have basically imploded. Obamacare would have gone away. Okay, and so it's extremely important that we have folks that really aren't subject to the whims of an electorate, say, that are supposed to interpret and impose the rule of law that we have, which ultimately is the Constitution. I don't think there's anything there necessarily. Case law, and in the beginning we kind of also referred to this as civil law, right? But I tend to call it case law, so and that's precedent oriented or stare decisis, meaning we base decisions, judges base decisions, base rulings on things that have happened in the past, okay, or precedents, we would call that. There's advantages to it. It's somewhat predictable. We know that if a case was handled similarly in the past, that our case should be handled in a similar fashion. Okay, I'd argue that every case I was ever involved in, our lawyers, they would find precedents or cases that had been decided that they thought were similar to ours, had decisions that were what we were looking for, and so would of course assure us that we were on solid footing. And the problem was the other side had exactly the same thing, and and so the predictability of it I find interesting. There's so many cases and so many precedents, or so many past decisions, that it's difficult to say how predictable really it might be. Disadvantages, of course, volumes of cases. We got so many. It's very time intensive. You're like me. If you see somebody sometimes arrested or whatnot, and you wonder, geez, how come I've never read anything about that? Well, sometimes it just takes that long, to process those types of things. Very, very expensive. Dicta, so it says statements made that are not relevant to the decision. What that means is, oftentimes when the Supreme Court makes a decision, okay, there's the winning side, or the prevailing side will write the decision. They'll maybe express their opinion why they came to that conclusion. The non-prevailing side can write that as well and say what was their thought process and why did they disagree with that. And that can be important later on. Maybe at times in the future the Supreme Court might look at overturning a precedent, okay, which would be this one, and they might go back and look at dicta, what the thoughts were of the justices that didn't prevail the prior time. Okay. One other disadvantage is there's just this multitude of systems, right? We have a whole conflict, lots of conflicting laws. Okay, so the judicial process, sure, we use existing statutes and we use precedent, okay, but they can create law where none exists, and I think I've given you a couple examples in the past, like Miranda v. Arizona, which led to the Miranda rights, Roe v. Wade, which led to the rights for women to obtain abortions. Okay, those are laws that have been created by court decisions, and there's many more examples of that. Those are the ones I always find easy to remember off the top of my head. Refuse to apply case law or find unconstitutional, like they did with the Obamacare case that I was just talking about earlier, right? They basically said, we're going to step back from that and let the statute that they passed be the law of the land. Montana's court system, okay, and I think I said again, if you looked at ours kind of compared to the federal court, it's kind of similar, I guess, because here we've got a Supreme Court, and our Supreme Court acts as just an appellate court, okay. Our district court, here's the difference, is that our district court is also a trial court. When you looked at that federal system and they had an intermediate appellate court, that's all it is an appellate court, whereas our district court is a trial court, okay. It can, however, rehear cases from these lower courts, okay, justice courts, municipal courts, and city courts, okay. Justice courts are typically within counties, okay. There's 26 justices of the peace plus 37 judges who serve both justice court and city court, probably in smaller counties, right, and that maybe have incorporated cities and whatnot, okay. 37 judges, that's probably these same ones, right, or these 37, and judges who serve both city court and justice courts, okay. So real similar powers that we see between really a justice court and a city court. And in Montana, it just depends on where you're at, the rural nature of your community. Our justice court takes up more than one county, whereas in Yellowstone County, they probably have several justice courts. They probably do in Missoula County, probably in Flathead County, right? Our justice court covers Hill County, Blaine County, I think, in northern Choteau County, if I'm not mistaken, okay? And then municipal courts, there's just a few of those, and my guess is those are in bigger cities where they've just established some smaller city court types of things, but broken down to have more of them, whereas our city court's for the whole city of Havre. I'm guessing that this is for large municipalities, and they've broken it into different districts, if that makes sense. Okay. Again, I don't know that it's real important to know the difference, although we would typically call our justice court the small claims court. As you can see, where they serve both, guess what? It says serve both justice court and city court jury trial except in small claims. I would think that they would do small claims. That's kind of interesting. 26 justices of the peace plus 37 judges who serve both justices court and city court jury trial, except I think all it's saying there is that small claims would not be a jury trial. Okay, so small claims in those cases would not be a jury trial. Okay, because they're keeping the procedure trying to keep it pretty simple. The district court can rehear. Okay, again, so it can be. I was talking about justice courts here, and I got goofed up. Let me back up a minute. Justice courts are typically county courts. Okay, there's 53. What do we have? 52 counties, something like that. Okay, and so they typically cover the whole county, and in some cases, the cities within those counties. Right, that's kind of what we have there. District court up here is what we have in Havre that covers more than one county. Hill County, Blaine County, and northern Choteau County. Sorry, I got kind of a little bit goofed up there. So, okay, these handle small dollar things, small claims. Okay, they also handle things like speeding in the city limits, okay, or speeding in the county, okay, or small vandalism at Beaver Creek Park, or vandalism out at Fresno, or whatever the case may be, MIPs and whatnot. You're probably going to end up, if it's an MIP in town, you're probably going to end up in city court. Okay, if you're on the outskirts, if you're out in the park, for example, Beaver Creek, you're probably going to end up in justice court type of thing. Okay, when we get to the district court, we do have some misdemeanor. They'll handle all the state felonies, right? Criminal appeals, okay, that might come from down here too, and also juvenile cases. Tort contract, real price, more expensive ones, if they're above $7,000, they'll be in here, and all kinds of other things, estates, divorces, those types of things are handled in district court. And then ultimately our Supreme Court's and appellate court. Montana has two other courts, talked about a little bit, a water court, okay, and workers' compensation courts. They're specific courts that handle just those specific types of cases. I think this is part of your homework, and if you'd have looked ahead on the PowerPoints, then you could have just taken this off of there. So, and that's just some questions, I think, from the book. So that's it. Yeah, hopefully I didn't take too long. Well, less than a normal class period. So thanks for listening.